Hello class, how are you all? So today we are going to start another topic, that is copyright. So before going into the legal aspects, let me explain this copyright in simple words. So what is copyright? Many people take it as it is the right to copy, and uh, they copy the content, they copy the textbook material, assuming that it is their fundamental right. But friends, it is totally wrong. Right to copy here means the right to make copies of the particular work vests with the owner, vests with the creator of that particular work, not to the other people. So, as we have seen in the previous lectures, the very important intellectual property, that is the patents. Now, today we are going to discuss copyright. This is one of the very beautiful right, and through this particular right, the creator can protect the different kinds of work, such as literary work, artistic work, musical work, cinematographic film, sound recordings, etc. etc. So, um, this particular right derived from a very interesting case I would like to share with you all. There was a national photographer who went to take the photography of the animals in the zoo or in that particular forest. So he became very tired, and on a particular place he was resting. And in that particular point of time, a monkey or a gorilla came and randomly it clicked that photograph taking instrument, the device, and randomly one photo was clicked, not deliberately. And that photograph was clicked in such a manner that it was a very, very quality photograph, and it was appreciated by many people. And it became so popular that the monkey has taken this photograph, and monkey has skills. Now this matter went to the court of law, and then there was a huge debate whether the copyright must go to the monkey or to the photographer, and this debate continues. Some courts ordered that since it is the photographer must not be given the right, the copyright, because it is not, though the camera belonged to that particular photographer, but he has not used his skills, his art, and since the photo was taken by the monkey, so the photographer must not be given the right. Then other courts, again the matter was taken to a next higher level court, and the court opposed to that particular judgment, and it said that the photographer must be given the copyright, because though the photographer has not taken the photograph, but the particular photograph was taken with the camera which belonged to the photographer. So the right goes to the photographer. Then again, the matter was a very disputable matter. Then again, it went to the some other courts, and some courts denied that the photographer cannot have the photo copyright because the particular photo is not taken. So what if the camera belongs to that particular photographer? So, but again it was overruled, and it was adjudicated that the law is meant for the people, and it is not for the animals. And though the photo was taken by the monkey, but the monkey is not a human being. So the copyright cannot be granted to the monkey. So this way, this particular concept of copywriting evolved, and today we have in India we have Copyright Act 1957 with lots of rules and regulations related to the protection of the copyright. So we will discuss in detail. So what actually the copyright is? So copyright is the exclusive right given by law for certain term of period to an author, composer, etc., or his assignee to print, publish books and sell copies of his original work. So this is the meaning of copyright. So it is the exclusive right, it is the monopoly right which is given to the author of a particular work. And if the author wants to assign that particular work to somebody else, then the right goes to the assignee because it is an assignable right. So, it is given for what? It is for to maintain a fair play, reward the creative efforts. Thou shalt not steal means what? Whosoever has created that particular work, that person must have the sole right on that particular work. It should not be stolen by others. The credit must go to the real creator, not to the other person. Then exclusive rights for limited time. Now this creates a negative right upon the person because it restricts others from copying that particular work, from selling that particular work, distributing that work. So it imposes a negative right because it prevents others from copying or reproduction of that particular work. So it gives exclusive right for a limited time. Now this particular right is not available lifelong, throughout the life. No, it's not like that. Like every other intellectual property, this intellectual property is also granted for a particular period of time. So in general it is lifetime of the author plus 60 years in case of literary work. So why it is important, why it is necessary? Because it encourages dissemination of copyrighted works and for the public interest. So this is the idea behind the copyright protection. So from where this particular copyright originated? Like in India, the copyright law is similar to the England and Wales. First Copyright Act in England and the world. So the first Copyright Act was enacted in England and Wales in the year 1709, Statute of Anne. In 1970, the Act was enacted did not protect the foreign authors. This particular Act did not promote the foreign authors, and indigenous American literature suffered. So today we have Copyright Act 1976, one of the major copyright laws in the world. So majority of the laws which is adopted by a majority of the nations, that is based on the Copyright Act 1976. So in India before independence, we got the Copyright Act 1914, which was after the independence, which was replaced by Copyright Act 1957. So 1957 Act adopted many English provisions, introduced new ideas and concepts. Whatever shortcomings were there in the earlier enactments, all those were overcome in this particular enactment. So we will see what are the main features of Copyright Act 1957. So this particular law is valid from, though it was framed in 1957, but it was executed from 21st January 1958, and it created Copyright Office and Copyright Board. So this particular enactment provided the provision for copyright board and copyright officers throughout the country. It introduced civil and criminal remedies in case of infringement of the copyright law. So now we will see what are the main features. Main features, that is, it also included the performing rights societies, for instance, work like music, royalties, etc. Then the definition of categories in which the copyright actually subsists. There are different kinds of work. So this law provided for a provision for categorizing different kinds of work under different areas, and then international copyright, how to grant, how to protect the work at international level, and definition of infringement. This was the special feature of this particular law. Then the copyright law was amended in 1983 and 1984, and the objectives were Berne and Universal Copyright Conventions, that it was related to the grant of compulsory licenses by developing countries, publication by deceased authors. So if particular work is being done and the author is not known, the author dies, then in that case the government has the right to grant the compulsory license, or that particular work is taken away by the government of the particular nation. In 1984, the Act was based on discouraging and preventing widespread video piracy. So, since during that time lot of video piracy took place, so there was no any particular law to prevent this particular aspect. So, this particular Act was also included, this particular factor was also included in the Act of 1984. Then the latest 1992 amendment, which defined the ambit of the Copyright Board powers. As I told you earlier, that the Copyright Board was also established, which got so many judicial powers, administrative powers. So this was defined in this particular amendment, and it introduced rights for the performers, special rights for the performers. Then assignments and this licenses for copywriting and rights to the copyright owners. Now, it also explained the term for a particular copyright work is for how much time a particular copyright work must be given protection. So, depending on the nature of the work, owner of that particular copyright, and whether the work has been published or not, the most of the work, as I told you, that the protection is granted for a period of 60 years, and in case of broadcast reproduction, it is for a period of 25 years, and in case of literary work, the protection is granted for a period of 60 plus lifetime of the author. Like for example, if Lata Mangeshkar has sung any song, then after her death, as you know that she is no more, and whatever when she was alive, she must be getting some royalty when the cassettes were sold in the market. Now even after her death, her legal heirs are getting the royalty based on the number of copies sold in the market. So this is the benefit which is granted to the literary work, musical work, the singers, actors, etc. So the nature of copyright. What is the main characteristics of copyright? It is statute based on no registration necessary. Now this is a very special feature about the copyright law. It does not make registration compulsory. It does not ask that whatever work you have done, you must have get that work copyrighted. No, it is not mandatory as per the copyright law. This is a very special characteristic. So it says that there is no need for registration even if somebody has done any creative work related to literature, art, or any other type of work. which comes under the boundary of the copyright work, then in that case no registration is necessary. Once the work is done, means it is done. Even if you don't get it copyrighted, you reserve all those rights which you may get after the registration of your work. Then copyright is granted for the intellectual property. One has to prove that the particular work is creation of the human mind. It is being created by the creativity of that person by applying the intellectual knowledge, intellectual skills. So that is very important, and it combines different rights. Like it does not give only a right for only a single or a particular work. It gives right to various types of work, literary work, the right of reproduce in the hardback and the paperback editions, the right of translation, adaptation, right of distribution. All these rights are granted in a particular single copyright. Now this copyright is the combination of labor, skill and capital. Any copyrighted work requires all these three aspects. So it is the product of the labor, skill and capital of one man, which must not be appointed by another. So this particular definition is given as per law Atkinson, Mackinnon versus Copper AIR 1924. So this is very important aspect of the copyright. So copyright in the form of expression, not in idea, and very important about copyright. So copyright, in case of copyrighting a particular word, the idea may be old. It does not say that unlike the patent, the idea must be new. It asks that even if the idea is old, the expression must be new. So not the idea, the expression is protected under the copyright law. So there is nothing in the notion of the copyright to prevent a second person from producing an identical result. So anybody can, based on the same idea, can go for any kind of creative work and in a different manner. Like for example, if somebody has written a novel, then another person can make a movie based on that particular novel. Then any other person can play a skit or a drama on the stage based on the same novel. So here I mean to say that the expression must be different, the expression must be new, the idea will remain the same. So copyright only in material form. So it must be in the material form. Principle of fixation is applied. So friends, here I would like to explain that the copyright, what is the subject matter of the copyright, what actually is protected. So original, literary, dramatic, musical and artistic work. So it includes the main important aspect is the original, whatever work related to literary, artistic, dramatic or cinematography or musical or any other kind of work, that has to be original. That should not be copied. So this is the first and foremost requirement for a work to be copyrighted, including sound recording as well. So from here you can see what can be copyrighted, but it has to be original. That is the most important requirement. What does literary work include? Literary work includes novels, poems, short stories, books on any subject. Nowadays, in the age of technology, even the computer program is being included in the literary work for the protection under the copyright law. Then tables, computer, databases, songs, lyrics, computer software. What does computer software include? Computer software includes program manuals, punched cards, magnetic tapes, discs, computer printouts, computer programs. So all these can also be protected under the copyright under the literary work. What is the subject matter of the copyright? So first thing is, to sum up with, first thing is the work must be original. It must not be a copied work. It must be original. Second thing, work of authorship. Whatever work is done, the author deserves all the right as far as the copyright protection is concerned, and it is fixed. Fixed means it must be presented. It must be prevented on some particular form. Like for example, if somebody has sung a song, then it must be recorded somewhere so that it can be played many times and in different audiences. Similarly, if somebody has drafted a book, then that book has to be brought in a written form, in a hard copy, and that can be again converted into multiple copies. So that is, it has to be fixed. Then in United States Congress intended the wide reading of the term literary works. So in United States, many more things are being included under the category of literary work. So analogy between literary work and computer programs. So according to the US law, the genetic sequences are strings of symbols of the nucleotides of DNA. The DNA sequence containing coded genetic information for the synthesis of particular protein that is equivalent to application program of the computer. So this is also being included under the computer software, computer program, which can be protected under the literary right. So DNA as a compilation, combining various elements of DNA constitutes a compilation. Even the compiled work, the compilation work, which involves assembling of pre-existing materials, that is also part of protection under the copyright law. Selection and arrangement of the sequence elements are copyrightable. If, like here you can see how the particular computer program is being arranged, there is a particular sequence is maintained. Even this aspect is also a subject matter of copyright protection. So there is a very important doctrine, that is sweat of the brow doctrine. This applies to the copyright. So first thing is, originality has to be maintained. Originality in the labor expended in the collection and assembly of data is adaptable to DNA sequences. So as far as in the context of computer programming or computer databases, what here original means that somebody has to apply the mind, somebody has to take pains for arranging or collection of data and making them, arranging them in a particular sequence. So that is also protectable under the copyright. Researchers spend considerable time and effort. It believes that the researchers are spending a considerable time and effort to discern the sequence of gene they would have copyright due to the hard work. So anything which deserves some hard work, some pain, some labor, and though it may be taken from different sources, but by applying the body of knowledge, applying the logic, applying the intellect, if we are able to arrange that particular information, that particular knowledge in a systematic way so that it can be useful to the society, then such content can also be a subject matter of copyright. So sequence means original literary work. So section 3 of Copyright Design and Patents Act 1988 defines literary work as follows. It includes table of compilation and computer program. DNA sequence could be literary work as well, created by human mind, written. So originality was also explained, that work may be original even if derived from previous material, provided further dependent skill, useful labor, knowledge or judgment have been bestowed on its creation. So even if some knowledge, some judgment is being applied on existing material, existing source of information, then that would also be considered as the original work of the creator. Even nature of the subject matter can lead competent authority with one solution. In this particular case, this aspect also came into existence. The famous case Walter versus Lane, 1900 AC 539. In one of the important case, Eastern Company case, we can see what was the test for originality. In this case, the compilation of Supreme Court judgments is being considered. So, how the test for originality was done? The middle path approach adopted from the derivative works. If the work is based on some, if it is a derivative work, if it is derived from some original work, then in that case, the sweat of brow, as we discussed the doctrine of sweat of brow, will be adopted if that particular work was based on some hard work, some labor, some pains, some judgment, and partially the UK approach, that was the case of Ladbroke versus USA fees. So India follows, we follow the mid path, that is the Canadian approach, that is CCH Canada. So we follow the middle of the path approach. So as far as there is no reported case on the copyrightable of biotech subject matter, there is one case currently pending with respect to plant varieties on the basis of copyright and trade secrecy, that is the confidential information.